The fine arrived taped to my front gate like a warning poster. Bright red ink. Official seal. Notice of violation. Total penalty, $360,000. I stood there longer than I should have, rereading the number like it might change if I stared hard enough. $360,000. For what? According to the HOA, it was a combination of unauthorized land use, noncompliance with community standards, and a handful of vague clauses that sounded serious but explained nothing. The funny part was the signature at the bottom. The HOA president. A woman who had never once spoken to me directly. I didn't panic. I didn't call a lawyer. I didn't even take the notice down right away. Instead, I walked the property line, the same way I had dozens of times since I bought the land. Acres of open space, old fencing, service roads that cut through the neighborhood like veins. This place had history, more than the HOA ever bothered to understand. They treated it like an inconvenience, like land that existed only to be fined. I went inside, made coffee, and read the bylaws they'd attached. Page after page of authority they assumed everyone accepted without question. Buried in the penalty section was the threat. Failure to remit payment may result in legal enforcement, including police involvement. That line told me everything I needed to know. They weren't expecting resistance. I refused to pay. Not dramatically. Not with a letter. I just didn't respond. 3 days later, 2 police cars rolled up my driveway. Lights on. Slow. Careful. Like they were approaching a problem they didn't fully understand. I stepped outside before they knocked. One officer asked if I was aware of an outstanding HOA enforcement action and an unpaid fine. I told him yes and that I disputed it. Calmly. Confidently. He nodded, asked a few procedural questions, then said something that surprised me. "Sir, do you own this land?" I said yes. Then I added, "And a lot more than just this." That was when things slowed down. The officers didn't arrest me. They didn't threaten me. They asked for documentation. I invited them inside and handed over a folder I'd been keeping updated for years. Deeds. Parcel maps. Corporate filings. The officer flipped through it, his expression changing as he went. Then he looked up and asked, "Can you explain how your property relates to the HOA?" I told him the short version. Years ago, I'd acquired land piece by piece. Quiet purchases, old titles, neglected parcels no one paid attention to. Over time, it added up. Roads. Green spaces. Utility corridors. Eventually, I realized something most people never check. The HOA didn't just sit next to my land. It sat on it. Every common area they controlled? Mine. Every easement they claimed? Licensed through entities I owned outright. The HOA wasn't fining an outsider. They were fining their landlord. The officers exchanged a look. One of them stepped outside to make a call. The other stayed, suddenly very polite. He asked who else knew about this arrangement. I smiled and said, "Not the HOA board." When the officers left, no ticket issued, no demand made, I knew this wasn't over. HOA power doesn't collapse quietly. It pushes back. Hard. And when organizations built on assumption realize the ground beneath them isn't theirs, they panic. The $360,000 fine wasn't enforcement. It was a bluff. And the moment police got involved, that bluff became a liability, one that was about to expose far more than an unpaid invoice. By the next morning, the HOA board was in damage control mode. I knew because the emails started coming in, polite at first, then increasingly urgent. Requests for clarification. Invitations to discuss the matter informally. One board member even suggested the fine had been issued in error, as if 6 figures could accidentally appear on official letterhead. I ignored every message. Silence had worked for them for years. Now it was my turn to use it. Instead of responding, I went back to the records. The HOA was incorporated as a non-profit, but its authority depended entirely on land it never truly owned. Common areas, retention ponds, access roads. Every parcel listed under HOA control traced back to shell entities that I, or companies I controlled, had acquired long before the neighborhood reached full development. The original developer had structured it that way for tax reasons, then sold off interests quietly. Most homeowners never noticed. Neither did the board. I scheduled a meeting with my attorney and a forensic accountant. Not because I planned to sue yet, but because I wanted everything clean. If the HOA wanted to pretend I owed them money, I needed to know exactly how much they'd been collecting while standing on my property. The numbers were staggering. Over years, they'd levied assessments, imposed fines, and charged vendors for access permits. Millions in aggregate revenue tied to land they didn't own. That afternoon, the HOA tried a different tactic. They sent a final notice, threatening a lien against my property. That was the moment they crossed from arrogant to reckless. Filing a lien against land you don't control isn't just invalid, it's actionable. My attorney smiled when he read it. They've just made this very expensive for themselves. We responded with one letter.
Short. Precise.
It disputed the fine, rejected the lien threat, and included copies of deeds showing my ownership of every parcel the HOA claimed as common property. We also demanded they cease enforcement immediately and preserve all records related to assessments, fines, and land use. The board went silent. 2 days later, an emergency HOA meeting was announced. Homeowners packed the clubhouse. I didn't attend, but I didn't need to. A neighbor forwarded me the agenda. Legal exposure. Authority clarification. Police involvement fallout. My name wasn't listed, but it didn't need to be. I was the reason the room was full. Behind the scenes, the board's attorney was scrambling. The same police call they'd used as intimidation had triggered mandatory reporting. Once officers realized the fine was tied to a property dispute, it flagged the HOA's enforcement practices for review. Suddenly, their aggressive tactics weren't just unethical, they were on record. Homeowners started asking questions. Why was the HOA fining someone who owned the land? Why were police involved in a civil matter? Why had no one ever verified ownership of common areas? The board had no good answers. Only deflections. Late that evening, I received one more message. This time, it wasn't from the board, it was from the HOA's management company. They asked for a private call to de-escalate. I declined and replied in writing instead. I told them there would be no discussions until the fine was formally withdrawn, the lien threat rescinded, and a full accounting prepared. They didn't respond. Because once paperwork enters the picture, power shifts. HOA authority only works when people assume it's real. The moment those assumptions collide with documented ownership, the illusion cracks. And the board knew it. The $360,000 fine that was meant to scare me had become evidence that the HOA was operating far beyond its legal reach. This wasn't a disagreement anymore. It was exposure. And exposure is what organizations fear most, because it doesn't just cost money, it costs legitimacy. The crack turned into a fracture the moment homeowners started comparing notes. Screenshots of emails leaked. Copies of old assessments resurfaced. Someone uploaded a scanned map from the county website that clearly showed ownership boundaries, and suddenly, the HOA's common property wasn't so common anymore. People who'd paid fines for years realized they'd never once seen a deed. They'd trusted letterhead instead of law. The board tried to regain control. They sent out a carefully worded update claiming the situation was a temporary clerical dispute and assured residents that HOA authority remains intact. That line backfired immediately. Residents demanded proof. Not reassurance, proof.
Deeds.
Easements. Anything. The board had nothing ready. That's when the second police visit happened. This time, it wasn't about me. It was about the HOA. A homeowner had filed a complaint after learning the board attempted to place an invalid lien on property they didn't own. That escalated things fast. Filing false liens isn't just a mistake, it's a legal violation. Officers showed up at the management office, not to arrest anyone, but to document, to ask questions, to collect statements. The same tactic the board had used against me was now pointed squarely at them. I watched it unfold quietly. No gloating. No public statements. Just patience. Power doesn't need to rush when the other side is unraveling on its own. Behind closed doors, The HOA's insurance carrier was notified. Within days, coverage for board actions was suspended pending investigation. That single move crippled them. Without insurance, every decision carried personal liability. Board members who once voted confidently now hesitated. A few stopped responding to emails altogether. Then came resignations. First the treasurer, then the secretary. Each resignation email used the same careful language: personal reasons, time constraints, best interests of the community. But everyone knew the truth. They were stepping away before their names ended up attached to something worse than embarrassment. The management company followed soon after. They terminated their contract, citing irreconcilable legal exposure. Overnight, the HOA lost its administrative backbone. No accounting, no enforcement, no communication pipeline. Just a skeleton board sitting on a pile of unanswered questions. That was when my attorney advised it was time to act, not aggressively, but decisively. We filed a declaratory judgment action. Simple and surgical. It asked the court to formally recognize my ownership of the land and declare the HOA's enforcement actions invalid. No damages requested. No penalties. Just clarity. The kind that ends arguments permanently. The filing triggered mandatory disclosures. The HOA had to turn over records they'd avoided for years.
Deeds.
Financials. Internal communications. Meeting minutes. The discovery process alone was enough to terrify them. You can't hide assumptions once they're subpoenaed. Homeowners demanded an emergency vote to dissolve the current board. They got it. The vote wasn't close. People were angry, not at me, but at the realization they'd been governed by people who never confirmed the foundation of their authority. The board's reign ended not with a scandalous headline, but with a quiet tally and a locked office door. Throughout all of it, the $360,000 fine disappeared. No retraction. No apology. Just silence. Like it had never existed. But that silence spoke volumes. Because fines don't vanish unless the people who issued them know they were never enforceable to begin with. By the time the court date was set, the HOA was barely recognizable. New interim leadership. Lawyers on standby. Residents wary of every decision. And me? I hadn't raised my voice once. The irony wasn't lost on anyone. The HOA had tried to use authority to extract money from the person who owned their entire foundation. They'd called the police to intimidate, and in doing so, they'd invited scrutiny they couldn't survive. What began as a bluff had turned into a spotlight, and under that light, the truth did what it always does. It burned away the illusion. The court date changed everything, even before anyone stepped inside a courtroom. Just the scheduling of it sent a signal through the neighborhood that this wasn't going away quietly. Homeowners realized this wasn't some internal HOA dispute they could ignore. This was about ownership, authority, and whether the organization governing their lives had ever had the right to do so in the first place. In preparation, my legal team did something the HOA never expected. We opened the books wider than necessary. We submitted clean, organized documentation, chains of title, corporate structures, easement licenses, historical transfers, going back decades. Nothing hidden. Nothing rushed. It contrasted sharply with what the HOA produced, which arrived late, incomplete, and riddled with gaps. Entire years of meeting minutes missing. Financial statements that didn't reconcile. References to assumed control instead of recorded ownership. That phrase came up more than once. Assumed control. The judge noticed it too. During a preliminary hearing, the HOA's attorney tried to frame the situation as a complex misunderstanding between overlapping property interests. The judge interrupted him and asked a single question: "Can you show me where the HOA obtained title to this land?" The silence that followed was uncomfortable. Papers shuffled. The attorney admitted they could not, only that the HOA had managed the property for years. Management without ownership. That distinction gutted their case. Outside the courtroom, the fallout was immediate. Lenders financing homes in the HOA began asking questions. Title insurers reviewed policies. Real estate listings quietly changed wording, removing phrases like HOA-owned common areas. Property values wobbled, not because of me, but because uncertainty finally replaced blind trust. The interim HOA board tried to regain credibility. They issued a public statement acknowledging historical oversights and promising reform. They formally withdrew the $360,000 fine and admitted it was procedurally inappropriate. Still no apology, just legal language. But by then, it didn't matter. The damage was already done. I offered something unexpected. Not forgiveness, but structure. Through my attorney, I proposed a transition agreement. The HOA could continue limited use of certain areas under clearly defined licenses. No fines. No enforcement authority over my land. Annual fees based on market value. Full transparency. Independent audits. And one non-negotiable condition. The HOA would formally acknowledge, in recorded documents, that it did not own the land it previously claimed. Some homeowners hated the idea. They wanted blood. Lawsuits.
Punishment.
Others understood reality. Prolonged litigation would bleed everyone dry. Clarity, even if humbling, was the better option. The vote passed. The agreement was signed. And just like that, the HOA went from acting like a governing authority to what it always should have been, a voluntary association operating within boundaries it could actually prove. No more intimidation. No more police threats. No more made-up penalties. The court case concluded shortly after, not with a dramatic ruling, but with a formal declaration recognizing my ownership and invalidating all past enforcement actions tied to the disputed land. It was clean, final, unavoidable. Walking out of the courthouse, I didn't feel triumphant. I felt something quieter, relief. Not because I'd won, but because the truth was no longer buried under assumptions and letterhead. Everyone could see it now. The HOA still existed, but it was smaller, careful, stripped of arrogance. Board members spoke cautiously.
Decisions were documented.
Lawyers reviewed everything. Fear had replaced entitlement, and accountability had replaced bluffing. And all of it started because they thought a six-figure fine would scare me into compliance. Instead, it forced them to prove something they never had, that they were in charge. And once they failed to do that, the illusion collapsed completely. The neighborhood felt different after that. Not louder or quieter, just more honest. The signs didn't change overnight, but the tone did. HOA notices became cautious, carefully worded, stripped of threats and bold claims. Meetings were smaller, shorter. People listened more than they spoke. Authority, once taken for granted, now had to be justified every single time. The $360,000 fine never reappeared. No explanation. No correction notice. It simply vanished from the HOA's records as if it had never existed. But everyone remembered it. Residents talked about it the way people talk about near misses, something that could have ended very badly if one detail had gone the other way. The board avoided the subject entirely, which only reinforced what most people already understood. The fine had never been enforceable. It had been intimidation, nothing more. What followed was a slow, quiet unraveling of the old culture. Vendors who once answered only to the HOA now asked for proof of authority before doing work. Contractors requested written permissions. Insurance adjusters demanded clarity on land control. Even the management companies interviewing to replace the old one insisted on reviewing deeds before signing anything. The neighborhood had learned a hard lesson, and no one wanted to be the next one exposed. As for me, I didn't assert control loudly. I didn't need to. Ownership doesn't require announcements. I maintained the land the same way I always had, responsibly, predictably, with documentation for everything. Roads were maintained. Green spaces stayed open where licenses allowed. Nothing dramatic changed for most residents, and that surprised them. They'd expected retaliation, restrictions, power plays. Instead, they got boundaries. The new HOA leadership reached out once more, months later, asking if I'd consider selling portions of the land outright to simplify things. I considered it. Then I declined. Not out of spite, but out of principle. Selling would have turned clarity back into assumption. Licenses and agreements kept everything explicit. Nothing left to interpretation. Nothing left to bluff. Over time, resentment faded.
People moved on.
New residents arrived with no memory of the fine or the police or the emergency meetings. They just knew the HOA was cautious now, that rules were clear, that fines were rare, that threats were non-existent. In a strange way, the community became healthier because it no longer operated on fear. The former board members disappeared from HOA life entirely. A few sold their homes. Others kept to themselves. Their names still existed in old minutes and filings, but socially, their influence was gone. Power doesn't survive exposure. Once people see how fragile it is, they stop treating it like something permanent. Every so often, someone asks me why I didn't go after damages. Why I didn't sue for harassment, false liens, or abuse of authority. The answer is simple. I didn't need to. The goal was never punishment. It was correction. The moment the illusion of HOA supremacy collapsed, the system corrected itself far more effectively than any lawsuit could have. Looking back, the most ironic part is how avoidable it all was. If the HOA had asked one question years ago, who actually owns this land, none of this would have happened. But entitlement doesn't ask questions. It assumes. And assumptions are dangerous when paperwork exists. The police visit that was meant to scare me ended up protecting everyone else. It forced records into the open. It created a trail that couldn't be erased. It turned a private bluff into a public accountability event. Once that door opened, there was no closing it again. Today, the HOA still functions, but it no longer pretends to rule. It manages. It coordinates. It serves. Exactly what it was always supposed to do. And I still own the land beneath it. Quietly, legally, undeniably. The lesson spread beyond the neighborhood. Nearby HOAs began reviewing their own documents. Developers asked different questions. Boards stopped assuming and started verifying. All because one fine went too far. They tried to take $360,000 from someone they thought wouldn't push back. Instead, they exposed the truth. And once the truth is on record, it doesn't go away.